Okay, we'll start with Cross, Boat Solar. Yeah, thank you. I think I'll let them say it.
I think it's me, Mr. Chairman. Anybody ahead of me got...
Nobody from Vote Solar? Okay. Want to make sure. NAACP, Coastal Conservation League, Upstate Forever. Okay. Sierra Club. Okay. Mr. Elliott.
If I may.
I'm afraid it's you.
Yes, sir.
Oh, I'm not afraid it's you.
Thank you, Mr. Chairman. Mr. Fallon.
Yes.
If I may, let me ask you just a few questions. In your testimony, I thought you did a very, very nice job of outlining the history of Duke's efforts to obtain authority to recover pre-construction costs for the Lee nuclear facility. And if it would help you, I'll draw your attention to page 12. I don't know that you'll need this, but you testify that on December 7, 2007, in docket number 2007-440E, Duke, and I'll call it Duke, filed an application for approval of a decision to incur nuclear generation pre-construction costs. Do you recall testifying to that?
Yes.
All right. And you understand that that application was filed pursuant to a South Carolina Code Section 58-33-225. You recall that?
Yes.
And do you recall, just generally speaking, Mr. Fallon, that that code section was enacted as a part of the Base Load Review Act in 2007? Do you recall that?
Yes.
So you filed under the Base Load Review Act for recovery of pre-construction costs, correct?
Yes.
Now, you seem to be, in your testimony, you testify about the order in both the 2007 and the 2009 docket. So I'd like to show you, if I may.
Is that the 2009 or 2011?
Excuse me, 2011. Beg your pardon. I'd like to show you order number 2008-417 in a matter captioned Application of Duke Energy Carolinas for the approval of decision to incur nuclear generation pre-construction costs.
Mr. Chairman, I would just ask if counsel could provide me and also the witness in order.
Well, I'm happy to. I think the witness is looking at his. Would you like to see mine?
Do you need yours to do your presentation, or do you have an extra?
No, I just have mine. I knew Mr. Fallon would be prepared. I thought you might be familiar with it. Would you like to see
I am
mine?
familiar with the order, but I just want to make sure we're talking about the same order. So
yeah, but I mean,
you can bring it to me so we can at least confirm.
Happy to help. I'll say this loud enough for everybody here. I'm going to ask Mr. Fallon about the
Probably can work from my copy if you get
the 2011 order also.
Okay.
Okay? Good. Thank you, counsel. And I simply place this on the Elmo to ask you if this, at least from the first page, appears to be the same order number 2008-417 that you refer to in your testimony.
Yes.
And in that docket, Duke applied for about $230 million in costs to be approved by this commission for various pre-construction items. Is that correct?
Yes.
And the commission approved Duke's expending up to $230 million in its efforts to incur pre-construction costs at the Lee nuclear generation station. Is that correct?
I don't know if that's exact words, but that's approximately correct, yes.
Well, and if I may, drawing your attention to page 7 of that order, finding number 7, the finding states that Duke Energy Carolina has incurred approximately $70 million in project development costs through December 31, 2007. The company estimates that it will need to incur up to $160 million in Lee Nuclear Station project development costs during the period January 1, 2008 through December 31, 2009, in order to continue the necessary pre-construction work to preserve the Lee Station as an option in the 2018 timeframe. Have I read that correctly?
Yes.
And does that appear from your understanding to be a correct statement?
Yes.
And do you recall that the testimony before the commission in that docket from Ellen Ruff, who was in the employ of Duke at the time, that Ruff testified that Duke Energy Carolina would not file an application with the Public Service Commission of South Carolina for a CPCN for the Lee Nuclear Station until the second quarter of 2008 at the earliest. Do you see that on page 27 of that order?
Mr. Elliott, make sure you're keeping that lavalier hanging in front of you because they can't hear your live stream sometimes.
Yes, that's what it says.
And so it's fair to say that, that at the time, Duke anticipated filing for its Certificate of Public Convenience and Necessity perhaps as early as the middle of 2008. Is that correct?
Yes, that's correct.
But Duke, of course, never filed for a Certificate of Public Convenience and Necessity in 2008 or ever, did it?
Yes, that's correct.
Now, you also testify about a subsequent proceeding in 2011 where Duke sought an amended project development application. Do you recall that?
Yes, I do.
And I showed this to counsel, and I'm going to put the 2011 order, 2011-454, on the Elmo, just the front page, and ask if that appears to be a copy of the 2011 order.
Yes, it does.
Thank you. Now, in this proceeding, Duke sought to amend the 2008 order. Do you recall that to be the case?
I don't know about the exact legal process, but yes, we were coming in for an additional project development order.
All right, and if you just look at the label here, it says order approving amended project development application and settlement agreement. Do you see that language?
Yes.
And do you recall in that case, or do you understand, at least, if you don't recall in 2011, that one of your witnesses, Mr. Rogers, Chairman, President, and Chief Executive Officer of Duke, testified, and I'm on page 10, and I'm about two-thirds of the way down the page, and I've got it highlighted. However, he testified that the company will not move forward with building the Lee Nuclear Station until, 1, the regulatory regime is in place in North Carolina, allowing recovery of financing costs outside of a rate case in North Carolina, similar to the provisions contained in the South Carolina BLRA. 2, the COL is in place. And 3, all necessary approvals from state regulators are obtained. Do you understand? Were you there for that proceeding? Or do you recall that that was Mr. Rogers' testimony?
Yes, I do.
Now, as I understand it, North Carolina has never seen the wisdom of enacting a BLRA. Is that correct?
There is a project development statute in North Carolina. It provides for recovery of construction financing costs through a rate case, but not through a annual mechanism. So that was the differential between the two.
In North Carolina, I take it you don't get the upfront approval of prudency of the decision to construct the nuclear plants. You have to wait to the rate case to get that approval?
No, I don't believe that's the case. I believe that the North Carolina statute, you can go in for prudency determination. The difference between the two, I'm not the legal expert, but the primary difference between the two statutes was the ability to recover financing costs outside of a rate case through the tracker mechanism.
All right, so, and drawing your attention to page 17 of the order, number 2011-464, I ask you if the following...
454 or 464?
454, it looks like, from my order. I'd ask you if this is a correct proposition. The company must incur only those costs absolutely necessary to keep the Lee nuclear project available as an option in the 2021 timeframe. The prudency determination made in this proceeding applies only to the South Carolina allocable share of the additional pre-construction costs of $75 million without AFUDC, not to exceed $120 million with AFUDC for the period January 1, 2011 through June 30, 2012. Have I read that correctly?
Yes, you have.
And you understand that to be the order in this case, don't you, sir? This is correct. Correct?
Yes.
Now, I think in that docket, Duke came in and actually applied for $229 million in authority for pre-construction costs. Isn't that correct?
I believe so, yes.
And the testimony at that time was that a total of $479 million would be sufficient. $459 million would be sufficient to get you all through the period ending June 30, 2012. Is that correct?
I don't think it was through June 30, 2012. I believe it was through receipt of the COL, which I think was we were projecting in the 2013 timeframe at that point.
All right, sir. And but as a consequence, the Public Service Commission in its order limited you to $120 million through June 30, 2012. Is that correct?
Yes, it was pursuant to the settlement agreement.
Right. And to be clear, the Commission approved the settlement agreement, but you agreed to this order, correct? Duke agreed to the terms of this order, correct?
Yes, and I believe that we've followed it through the receipt of the COL and up to this point, so yes.
And I do want to talk to you a little bit about that. I mean, you think it's important that to follow the existing orders of the South Carolina Public Service Commission. Isn't that correct?
Yes.
And I think you testified that in so doing, that Duke has consistently filed all of the quarterly documentation required by this commission in that order number 2011-454. Isn't that correct?
To my knowledge, yes.
And you understand that that the company has been filing regularly a report with this commission saying that the North Carolina General Assembly has not enacted a Base Load Review Act or something similar. You recall those filings, don't you?
Yes.
And you recall, if no other reason from Ms. Smith's testimony, that the company has been filing these quarterly reports informing the commission how much they've spent on the pre-construction efforts for the Lee nuclear station, correct?
Yes, that's correct.
And I believe that you testified that although Duke was authorized to spend up to $350 $50 million on pre-construction costs through June 30, 2012. Duke only spent $251 million during that period. Isn't that correct?
Subject to check, yes.
And I think you testified that after June 30, Duke has spent in about $271 million after June 30, correct, of 2012?
I think that's approximate. I have to look at the numbers again.
Now, after June 30, 2012, Duke never came back in under Section 58-33-225 for any more authority to expend costs on for the pre-construction efforts at the Lee Nuclear Station. Isn't that correct?
So while that is correct, I think there's some background information that would be beneficial here. So if you look at the trajectory of this project, we started out in the 2005 timeframe after the Energy Policy Act. There were significant financial benefits, on the order of billions of dollars of production tax credits. So we were pushing forward on things like ordering long lead equipment, site excavation work, site prep, detailed engineering work. And so when we came in for the first project development order, a lot of those types of activities were included in the cost. When we came back in for the second project development application, the project pivoted. We were unable to come to an agreement on an EPC agreement with Westinghouse and Shaw. And at that point, the commission told us in the order and in our settlement agreement that we were to preserve the nuclear option and we were only to spend those costs necessary to deliver the project by the timeframes needed in our integrated resource plan, which at that time was in the 2021-2023 timeframe. So that is exactly what we did. So we have followed the settlement agreement and the commission's order to the letter, right? We ramped down spending. We didn't commit any dollars to long lead equipment. We didn't commit any additional dollars. We only spent those dollars necessary to keep the option available to deploy this project in the 2021 to 2023 timeframe. So with that as background, after we got, after that time period, since we believed that we were following the order, we decided that we did not need to come back in for an additional project order. We decided not to. We didn't. And even in Section 3 that you showed me earlier, that was a pre-authorization for a specific period of time. It doesn't represent a cap, nor is it a requirement that we get that pre-authorization. It was just, that was a pre-authorization, and it doesn't guarantee you. It just says that any additional dollars and work that we did had to be deemed prudent, and I would think that no one in this case has challenged the prudency of the work and activities that we performed, and we've had other, in North Carolina, they hired an independent party to come in and evaluate the prudency of our activities and found that we had done everything in a prudent manner, and the North Carolina Commission found that our activities were prudent.
Thank you. And North Carolina, I think they awarded you some costs up there, but nuclear construction pre-development costs, but they didn't authorize return on those costs, did they?
The particular statute that we were under in North Carolina, they did not. It was silent on the matter. I think, Duke, we disagreed with that decision, but it was the statute was specifically silent on that matter, and the commission made their decision.
So you would agree with me that the commission didn't award you a return on your pre-construction nuclear development costs for Lee Nuclear, correct?
They did not, as I understand it, they did not provide a return during the amortization period. Yes.
All right. And so what I think I understood you to say was that Duke didn't think it prudent to obtain an order of this commission authorizing it to spend a total of $559 million in pre-construction development costs. Is that your testimony?
I don't believe that's what I said. I think you're twisting the words a little bit there. What I said was we were following an existing order, and we did not see a need to come back in because we felt that we were in alignment. And as you asked me earlier, do we follow the commission's orders? So we were following the commission's orders.
All right, sir. And we can agree that it's prudent to follow the commission's orders, can't we?
Yes.
And we can agree that if there's any question about the need to file for an amended base load review order, it would be prudent to err in favor of applying for an order to comply with the law, can't we?
I'm sorry, I don't quite understand your question. There's a few twists and turns.
We can agree it's prudent to follow the law, can't we?
Yes.
Now, you understood Ms. Smith's testimony that as of June 30, 2012, Duke had incurred approximately $68 million in AFUDC. Is that correct?
I believe that was correct.
Well, and if I put the exhibit on Elmo and point to the $68 million, would that help refresh your recollection?
Yes.
And so today you're asking for $248 million in AFUDC?
We are asking for the South Carolina allocable portion of that amount, yes.
And and the $68 million is the system-wide AFUDC as of June 30, 2012, correct?
Yes, that's correct.
All right. So we can agree that from June 30, 2012 until today, another $180 million in finance charges have accrued on your expenditures since in the last 7 years?
Yes, that's approximately correct.
And again, it's your testimony that you didn't feel the need to come in for an amended pre-construction review order?
I believe I said that we were providing quarterly updates to the commission, and we believed that we were in compliance with the 2011 order, and as such, we elected not to come in for a predetermination. Again, the order was for pre-authorization of costs. It did not say that any specific costs were prudent, so we still had the same burden to prove that the costs we spent and the work that we did was done in a prudent manner. And I believe that no one in this case has challenged the prudency of our efforts, and North Carolina has both an independent consultant and the commission has ruled that our efforts were prudent.
And you did not ask for any recovery of these costs in your, Duke did not ask for any recovery of these costs in its 2013 rate case, either did it?
Not that I can recall. I don't know what the mechanism would have been at that point in time, since it was an ongoing activity and we were complying with the commission's order and the commission's 2011 order.
Good. Thank you very much. Thank you, Mr. Chairman.
Thank you, Mr. Elliott. Walmart. Okay. ORS.
No questions from ORS.
Thank you. Anybody I'll leave out? Commissioners. Commissioner Whitfield.
Thank you, Mr. Chairman. Thank you both for your presentations. As Mr. Elliott said, both of you gave a good recap, if you will, of the history of the Lee nuclear site. And got just a question, I guess, mainly for you, Mr. Fallon, maybe one for you, Mr. Diaz, in a second. But I first must say that Mr. Gartitego must have understood what I meant when I misspoke, or either he was too nice to not admit it. But what I said when I was talking about the NRC licensing process, I was talking about the letter, that notification that came about the public hearings. I do realize that it was a much longer process than he and I had the exchange. Now, the original order for pre-construction was just before I got on the commission, and so was the filing before the NRC, but I was here for the 2011 order that was just discussed. And that said, Mr. Fallon, you had a lot of discussion with Mr. Elliott just now about this facility being in the IRP for many years, and you, at least on one or two occasions, stated that for in the 2021 to 2023 time frame, and I'm sure you probably know this, but South Carolina law, we don't have quite the teeth in the IRP process that other state commissions do. So, in your opinion, Mr. Fallon, is it practical to consider the future use of that reactor in light of the current climate with nuclear? And also, do you still include it in the IRP process going forward?
So I'll start with the first part of your question is, do I still think that it may be built someday? It just summarizes, and I think, Duke Energy Carolinas has an obligation to plan for the long term, plan for safe, reliable, clean, and cost-effective energy. And it's not just for next week, next year, but it's for the next 50 to 100 years. So with that as my background, I believe that Lee may be built someday, right? It's going to be, and we wouldn't pursue it unless it was in the best interest of customers. I do know, or I believe, I should say, that a lot of companies are looking to decarbonize. I think our country is looking to decarbonize. And I believe if you're serious about decarbonizing, that nuclear has to be part of the solution. We have an extremely well-run and nuclear fleet today, and I hope that we can operate those for many, many years into the future with relicensing and other opportunities. However, today we don't know what the cost of that option is, and if the Carolinas still want to have a clean, reliable portfolio, that I think nuclear could be a solution to that in the future, and it provides us an option depending upon what happens with relicensing and government regulations and customer demand growth, electric vehicles, any of those things that could drive it.
Well, I'm sure you're obviously watching the AP 1000s down in Georgia and the AP 1000s that are being built in other parts of the world, and watching kind of curiously and I guess taking notes of lessons learned.
Yes, absolutely. So part of our strategy, and I think we were very consistent once we couldn't get to an EPC contract, is that it was our desire to, make a decision with respect to the Lee project after receipt of the COL. And the thought there is that you would have experience from China, you would have experience from VC Summer and Vogel, the engineering, and probably one of the challenges that all the first mover plants ran into is that engineering wasn't sufficiently complete when they went to the field. So we wanted to be third so that we would be able to take advantage of that. And so that's why I believe that the COL is a valuable asset for Duke Energy Carolina customers. And, your second part of your question earlier was, do we still include it in the IRP? I believe we do. It shows up only in certain scenarios now where you can't relicense and there's potential carbon regulation. But we continue to evaluate whether this asset would be in the best interest of our customers.
So sometimes being last is not a bad thing.
No, absolutely. Once earlier I talked about how we kind of got in the race like everybody else because there was significant financial benefits to being up first, which were called production tax credits. Right. And for a plant the size of Lee, they were approximately $2 to $2.5 billion of value that would have accrued to the owners and the customers of those plants. Once we didn't get any, once we did not get an EPC agreement and we weren't going to be able to meet those deadlines, then we strongly believe that, okay, we need to step back, learn the lessons, and recapture some of that value by learning lessons from the existing facilities.
Well, thank you, Mr. Fallon. Mr. Diaz, what is the value of the COL of an abandoned nuclear plant if the probability of future nuclear construction at the site is low? And a second part of that, is it reasonable to assign value to the asset which may not reasonably be expected to be used?
Well, the value of a COL, it lies in many factors. One of the factors is how long it is. Nuclear is not a short-term business. You know, these plants that you have now serving South Carolina and North Carolina are about to be operated for at least 60 years, maybe 80. So contrary to other kind of permits, gas or coal that expire in 2 years or 3 years, the COL is essentially not expiring because the 40 years will not start until the time that you're building the plant. So you have the investment that was made into not only obtaining the permit, but into developing a site suitable for large power production is preserved and usable. And that is a valuable asset. It's not only valuable, it is tangible and can be traded. It continues to exist. It doesn't disappear. And the value could be really extraordinary if it comes to the point in which nuclear occupies a rightful place in the commercial production of electricity, which presently we all know, due to the gas, is not. So it is a different animal. It's an animal that provides the capability of building a plant when you have the proper economics and the proper technologies and the proper experience, when it can benefit your customers the most. That is the intrinsic value of a COL, and it's kind of unique. The other tangible values is that you have actually developed all the elements of a site which really has the water, the location, the access to transmissions, all of those things that are necessary for large production or power have been already clear from the environmental viewpoint, from the human population viewpoint, from, all of those aspects, including, seismic, everything that you need to do are there. So it is something of value. And yes, it is many companies, large companies, have already obtained it and are keeping that value because it could be used. Nobody can guarantee it. It could, it have to be economically viable. And I think that Duke made the right decision in saying, I have a great asset, but I'm not going to use it until it's beneficial to the people of the Carolinas.
Thank you, Mr. Diaz. That's all I have, Mr. Chairman, for this panel.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Fallon, I think you've probably answered one of my questions about your nuclear fleet. I assume that from your answer to Mr. Whitfield that you continue to attempt to relicense your nuclear fleet in the future.
I think there's Mr. Capps is a witness who's going to talk about nuclear, but what I will say is that I believe all of our plants are good candidates for relicensing, and we're strongly evaluating that. And no one has, I don't believe, I've been out of the nuclear department for a couple of years, but I think the first wave of second license renewals are about to be submitted here in the next year or two, so we'll know more about that process as we go through that.
Thank you, sir. One other question I have for you, and you might want to look at your direct testimony. On page 6, the North Carolina Public Staff was concerned with costs associated with the Lee Visitor Center. as well as the AFUDC?
Yes.
Okay. I think they disallowed the cost?
Yeah, so we had a slight disagreement over whether or not the visitor center was needed in order to meet the deadlines in the IRP. The name itself was part of the issue there, is that the idea was that we were developing a site or a building that was outside the protected area where we would do initial construction phase, construction and engineering work on the site, and then eventually turn it into a visitor center. And so we had done some pre-engineering, or we hired an architect and a design to design that building, and it was those specific costs. I think it was approximately $500,000 worth of design work that we had done that was excluded from the North Carolina rate case.
Okay. Thank you, sir. Thank you very much, Mr. Diaz. Happy to have you here with us too, sir. Thank you, Mr. Chairman.
Thank you. Commissioner Belzer.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
Mr. Fallon, following up briefly on what Commissioner Hamilton just asked with regard to the visitor center, and on a question that I'd asked Ms. Smith earlier, the visitor center was one of those exceptions from the North Carolina order, was it not? That
Yes.
was removed, and the other exceptions to the North Carolina order that were removed from this were, do you recall?
The land. There were some land costs that were pulled out, and then the return component during the amortization period.
This is going to be real basic. Tell me what is at that site. What are we talking about?
You mean right now?
Mm-hmm. Yes.
So it's about 3,000 acres of land. The former Cherokee nuclear plant, there was partial construction there. We had demolished that, and we pulled it down to the.
So they can't film another abyss there?
No, they can't. But there's dams, and there are access to the Broad River runs right by the site, so you have access to water for plant operations. But generally, it's 3,000 acres, and then we have another tract for the supplemental cooling pond.
Okay. So, what's consuming all this money to maintain that site? I mean, what work is being done there to all this money that's being spent?
Which dollars are you specifically talking about?
All that y'all are trying to recover.
The dollars we're trying to recover were the work that we did to prepare the site to be able to construct by 2021 to 2023, and then all of the licensing work that we did. So we spent significant fees. Let's say it was $25 million developing the application, and then I think it was about $125. I have to look at my testimony for an exact number, but in NRC review and fees. So there was significant dollars, not specific to the land and the facilities at the site, the warehouses and such, but this was the work to get the application reviewed by the NRC.
So after this case, and in the next rate case, are there going to be requests for additional dollars, or is this the end right now?
So we have...
With regard to this site?
So we have a license for this site. So from the NRC's perspective, it is an operating plant without equipment. So there are certain regulatory requirements that we have. It's relatively small. It's approximately $200,000 a year that are in mandatory regulatory filings that we are projecting in costs for this. That would just be part of our normal nuclear department operating costs. Okay. So it's not significant. There's no more.
Just filing costs, not something several $1 million that would.
No, it is. There's an annual requirement to update your final safety analysis report, and so the individuals and the time they spend doing that work is the cost, and any cost that the NRC sends us for their review of it.
I made note, and I had it in my written notes, and I'm sorry I don't have the page number in your testimony, but there was a sentence talking about reduce costs to only those necessary while preserving the ability to resume work. So are there, other than that the filing with the NRC that you just mentioned, are there going to be activities at that site to come under that phrase I just wrote, I quoted?
I mean, there may be some site maintenance, mowing the lawn, but minimal on an annual basis type cost. Right? I think we no longer have the security there, but we have to do some minimal maintenance. There's a dam on site, so you have to do inspections to make sure that it's safe, but not, like you said, these are thousands of dollars, not millions of dollars type costs.
Thank you. Mr. Diaz, just a question or two, if I might. You had a discussion in your testimony about the TVA and the Watts Bar site that had been discontinued back, when was that, in the 80s?
In the 80s, 1983, I believe.
And then they resumed in 2007, 2008?
Yeah.
Is that correct?
About that, yeah.
And one of those plants has actually been completed to...
It's completed and it's operating, yes.
Do you have any idea of what the cost implications or what costs were expended with regard to that plant from the time it was abandoned until it was resumed?
There was a normal cost of maintaining, the presence, preserving the site. That the license was suspended, the license was reinstated. It was a different type of license, but it was reinstated. And then the big cost, of course, was building the reactor. Reactor was about 50% built, and then they actually completed it. And it cost a significant amount of money, like $4.5 billion
for the construction of the plant.
Construction to operation, yes.
You've testified about the intrinsic value of the COL, and you stated in what response to a question from one of the other commissioners, I believe, when you have proper economics to resume the plant. And based on your experience, does it look like there would be a resumption of construction of a nuclear plant at the Lee site?
My guess is just a guess, but the answer is yes. I consult in many places in the world, and this is not the only place in the United States that have sites under consideration. I work in another one of those in Utah. Utah is now experiencing a phase in which the coal plants are being retired, gas is coming over. It's just becoming, from a dependence on coal, a dependence on gas. And so the answer is yes. The answer is that I believe that we have gone through a system transformation where coal was the dominant fuel and nuclear was 20% of the electricity, into which gas has now replaced coal as the dominant fuel of the land, and there is now a dependence of gas. We believe in the industry, not only the nuclear industry, but the energy industry, that is very important to have a portfolio of different components. You cannot depend on one fuel. And nuclear has very attractive features, very costly to build, but it have a very steady and very low production cost. So once you get it built, they work for a long time, and they work cheap and consistent, produce enormous amount of energy, stabilizes your grid. So there are a series of factors that actually are favorable to nuclear. Whether it will get there, if I had that crystal ball, I would be making money on Wall Street. But the reality is that I firmly believe that there is a very good chance that by the year 2028, 2030, nuclear will be in a position to restart and occupy a portion of the energy infrastructure of the United States.
You were following that very closely, Mr. Fallon. Did you have something to add to that?
Well, I thought his answer was very good, and I think that, again, you have to look at our mission as a utility is to plan for the long-term system and have options depending upon what comes up, whether it's carbon regulation, if plants don't get relicensed. So this, I believe, is a very valuable option for our customers because it allows us to deploy nuclear in a much faster time frame, and it allows us to significantly reduce the risks that some of the first projects like Vogtle and VC Summer experienced.
Mr. Diaz, because the combined operating license was filed for the Westinghouse AP1000, is it correct that years from now, if resumption of the site, if construction resumed, would it be limited to that type of reactor?
It could if you choose to do so, but it is not exclusively limited. The applicant can actually, at the time, choose another reactor and go through the process. It will take another 4 or 5 years if things are correct.
That would have to start the process over, would it not?
Not completely. You will have a series of portions of the license that will be applicable. Everything regarding to the site, seismic, a lot of the real, steady factors will be there, and so you will have something that exists and don't have to change it. But yes, everything was. If you change the technology, it will be a completely different technological application. You will have to rely on a different certification of the safety of the plant. So it will be different, but it is possible. It has been done. There is a company that already changed 3 times its reactor type in the United States in the last 15 years.
I just am curious as to the cost that would be incurred, but that'll be a future proceeding and what could. Okay. Thank you both very much. Appreciate your attention.
Thank you. Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Fallon, I want to refer to your file direct testimony. Do you have it handy?
Yes, I do. Let me.
All right. Would you turn to page 25, please? Let me know when you get there.
I am there.
If you look on, beginning on line 6, there was a question asked, how do the 2018 Baseload Review Act amendments impact the Lee nuclear project? And your answer was beginning on line 8.
Sorry, did you say page 25?
Yes, sir. Could be page 23. I've got 2 different references to it.
All right, I'm
Do you
there
see
now.
me now?
Yes.
Okay. So let me start over. The question you were asked is, how do the 2018 Baseload Review Act amendments impact the Lee nuclear project? Do you see that question?
Yes, I do.
And your answer was, quote, while I'm not a lawyer, I have been advised that because DE Carolinas does not currently have any requests made pursuant to Article 4, Chapter 33, Title 58, pending before the Commission, Duke Energy Carolinas is unable to request recovery of the abandoned Lee nuclear project pre-construction costs pursuant to South Carolina Code Annotated Section 58-33-225G, end quote. Was that your testimony?
Yes.
And so you were of the opinion that when the Baseload Review Act was repealed in South Carolina, by what we commonly refer to as Act 258, along with that went any chance to recover cost for pre-construction in South Carolina.
I guess the clarification, I don't believe it eliminated our ability to recover pre-construction costs. I believe that we're unable to recover them under that specific statute. Again, I'm not a lawyer, I'm an engineer, but
Well, how else would you recover them?
there's been previously, when you cancel a project or abandon a project, prior to the Baseload Review Act, there were opportunities to recover costs of those projects.
But that was your testimony. You were of the opinion that they're unable to request recovery of the abandoned Lee nuclear project.
Pursuant to, I think there's a pursuant to that specific statute or code, whatever, I'm not.
Yes, sir. Okay. Well, just from a practical standpoint, if the Baseload Review Act has been repealed in the South Carolina, and you made the application under that act, don't you lose the chance to come back unless you've got a pending request, which the company had no request prior to repeal of the act? Isn't that foreclose a recovery?
I don't believe so. I think it forecloses recovery. Again, I'm not a lawyer, but I think it forecloses recovery and the terms of that particular statute. However, I believe general South Carolina statutes allow us to seek recovery of these costs.
Well, that's something we need to look into, don't you agree? Just examine that question further. Since you had some doubts about it in your testimony.
I don't. Could you explain to me what my doubts were?
Well, you just said it couldn't be recovered, and so I just took you at your word in your testimony in that portion.
I don't mean to be dense, but I think I say the cost can't be recovered pursuant to that specific statute.
Okay.
There are other statutes within.
All right. Do you know what they are?
I'm not a lawyer.
Yes, sir. Is there someone that perhaps could tell us later in the hearing?
I think even in the ORS testimony, they point to specific statutes for the treatment of these costs.
All right, sir.
I don't remember the numbers.
Mr. Diaz, I, like you, am a dreamer, I think, at times, and I'm also an optimist. But I think we can agree that no one is going to build an AP-1000 nuclear reactor anytime soon in this country. Is that true?
I am not sure, but I would say in the next 5 or 6 years, the answer is you're correct. After 5 or 6 years, I don't know. There are 4 AP-1000s operating in China now.
Not in the U.S., though.
But there will be, most probably, will be one in the U.S. by 2021, so 3.
Where is that?
In Vogel.
Yeah. They're behind schedule and way over budget. Is that right, in Vogel?
That is correct.
And no end in sight.
Oh, yeah, there is end in sight.
Well, who's going to build it? Because Westinghouse is bankrupt. Are there other companies out there that are building that particular reactor?
Yes, sir.
Who?
Bechtel. Oh. And several other architects.
Yeah. But it would take 5 years, as you testified earlier, just to get a license.
Well, they have the license.
I understand they have one for an AP-1000.
Yeah, they have a license. They don't need to get another license. Right. They can finish and they can operate their plant. They don't need another permit. It's done and over with.
It wasn't one consideration by Duke Energy, Carolinas, the fact that the federal tax credits expired and no longer available, are they?
They are. They just got renewed precisely this week, I believe.
Okay, so I'm learning something. They've been reinstated.
Reinstated.
All right, at the same levels that they were before?
I think a little more.
Okay, that's good news. So a lot of things would have to happen, though, for it to be economically feasible. You'd agree with that?
Yes, I certainly would agree.
As long as the price of natural gas is low, it's going to be the primary go-to fuel. You agree with that?
If that's the only consideration, yes, but there are other considerations in a choice of fuel. And the other considerations, we are seeing them coming, is the potential effects on the environment, is the CO2. It's actually, the fact that there is a need for a series of different sources. You can't rely on one, because then if something happens, just like what happens to gas in the early 2000s, when the price went out of the roof and companies couldn't practically pay their bills. So there are more than one consideration.
I understand. And I agree. It's always good to have a diversified portfolio.
Absolutely.
So, yeah. Thank you, sir. I appreciate you being here today.
Thank you.
Thank you. Okay. I have just one question, Mr. Fallon. On your pre-file direct on page 34.
I'm there.
Okay. From line 18 through 22, you're talking about NCUC public staff. They say they concluded the cost incurred by DE Carolinas in pursuit of COL, including cost associated with pre-construction site development, land and right-of-way purchases, supply chain, construction planning, detailed engineering, operating planning, post-COL. Costs were reasonable and prudent with little exception. What were those exceptions and associated costs? You probably told that a little bit of that to Commissioner Belzer a minute ago, but I just want to make sure.
Yes, that's exactly correct. It was the cost associated with the design of the visitor center, the $500,000. It was the removal of the non-depreciable land, and then it was that was just the cost, and then there was another. The public staff only ruled on those particular issues. So it was those two items that they found prudent that were excluded from their prudency finding.
Okay, thank you. Dr. Diaz, I had a question, but everybody else has asked the same question I was going to, so you're off the hook with me. Any other questions? Commissioner Howard?
I'll make this quick, and either one of you can answer. What do you think the future of the small nuclear reactors?
How much time do I have?
How about a minute, less than a minute? Chairman will kill me if you go over a minute.
Small nuclear reactors offered a complete different way of building a reactor. That's what they offer. You can build it in a plant, and you can transport it, and you can load it. So it tries to get away from this massive deployment of people and supplies that sometimes are not there. And so it is a good idea, a very good idea. The issue is how small is small, and that's what the industry is dealing with. It is possible that a reactor, which is an expensive machine to build, not so much to operate, but to build it is expensive. Below a certain site, it becomes, too expensive. So that's the dilemma that is happening. But I do believe that eventually small reactors that are built in a plant rather than on site, and they are completely done by craftsmen that do the same thing day after day, will be extremely good and will bring nuclear back in a different scale to this land and other places.
Thank you. I was going to tell Commissioner Howard, like I told my preacher one time about the 12 o'clock hour, you can talk as long as you want to, but I'm leaving at 4:30. Mr. Marzo, any redirect?
Mr. Chairman, I do. I can be done by 4:30.
Go for it.
I'll start with you first, Dr. Diaz, and I'll go backwards to forwards. I think Commissioner Irvin had asked you some questions about the future of nuclear in the United States, and there was a discussion about Vogtle. Isn't it correct that currently Vogtle is working with Bechtel as a consortium, as a member, as a partner to build future nuclear plants?
Yes.
Okay. And as at this point in time, are you aware or what the schedule is or how Vogtle is doing in terms of its current schedule?
Yes, I believe that the last report that I read, things were actually beginning to fall in line in according to a schedule, and that the schedule of 2021 for the first plant has been given as high as an 80% probability of occurrence, and 2022, 2023 for the second plant. So those seems to presently, and all I can do is go by what I received. It's that they are now working towards completion.
And one last question on that point is, in terms of national support, are you aware that the Trump administration, I believe, announced this week through Secretary Perry, additional loan guarantees or extension of loan guarantees? Am I correct about that?
Yes, you are.
Mr. Fallon, you were also asking questions about the law, and I realize you're not a lawyer, so I'm not going to ask you to be a lawyer today, but you took advice of counsel, I understand, in drafting your testimony. The Commissioner Irvin had asked you some questions, I believe on page 25, question line number 6, which was about the impact of the BLR repeal. If you would, for me, if you would read the Q&A directly below it, which starts on line 16, and talks about the prior enactment of the BLRA, the Commission had previously had precedent in terms of the recovery of abandoned plant. Is that correct?
Yes.
Recitation of your testimony?
Yes, it is.
Okay. So you talk about the precedent of the Commission even prior to the BLRA, correct?
Yes, that's correct.
Okay. And even within that precedent, there's nothing that permits the company from requesting, in this case, and I know that there are differing positions, but requesting this case a return on the unamortized balance, correct?
Yes, that's correct.
Now, you were asked several questions by Mr. Elliott around the prior orders that actually came under the project development portion of the formerly BLRA. Do you recall those?
Yes, I do.
And he asked you some questions that would lead one to believe that he was suggesting that the company had not complied with, for example, the 2011 order. Do you recall those questions?
Yes, I do.
Okay, and I believe this morning when he was talking to Ms. Smith, he had asked some questions in relation to there being a cap. Were you here for that?
Yes, I was.
Okay. And does the word cap appear within the order from 2011?
No, it does not.
Okay. And in fact, if I look for the wording in 2011, I believe the wording is the term prudency determination. Is that the word that's used in that order?
Yes, that's correct. That was how the project development application and order process worked, is that you would get a determination that the decision to incur nuclear development costs was prudent, but they did not approve specific costs.
And that's an advanced determination, correct?
Yes, that's correct.
So is it your understanding, or do you know if the company would be required to get that in order to incur additional costs?
No, I don't believe so. And if you look at the time frame between the 2008 order and the 2011 order, there was a period of 2010 that was not covered by a project development order, and the Commission said it was not going to rule retrospectively that it was prudent, but that continued pursuit of new nuclear was in the customer's best interest. So I think we have precedent that we had periods of time where we didn't get pre-approval, and the Commission still believed that it was prudent in our pursuit of new nuclear.
And is it the company's position that they continued to comply with the 2011 order even after the period of time in which the predetermination amount had passed?
Yes.
Okay, and was the 2011 order based upon a settlement between the parties?
Yes, it was.
Okay. And I believe Mr. Elliott's client was one of the settling parties. Is that correct?
Yes, I believe he signed the order or the settlement agreement.
Would you turn to the actual? Do you have the actual settlement agreement that was appended to the order from 2011?
I do.
Okay. Would you turn to page 4 of that settlement agreement? And where I'm tempted to use the light, which I have not had a chance yet to utilize, I will try to just work off of the page, which is page 4, paragraph 2. And I'll be very brief, Mr. Chairman. I'll just ask a couple of quick questions on this. When I look at this paragraph, this is particularly the governing paragraph of what the company was required to do as it pertains to the authority granted in 2011, correct?
Yes, that's correct.
If I look at this paragraph, and I'm going to ask you to opine on this, Mr. Fallon, when I look at this paragraph, one of the things the company was required to do was to maintain the current schedule for obtaining the combined operation license for the project in the 2021 through 2023 time frame. And that's summarizing what's there. Is that a fair summation of that requirement?
Yes, we were expected to continue to pursue the license and any work that would be needed in order to deliver the project by the 2021 to 2023 timeframe.
Okay, and did you do that?
Yes, we did.
Okay. And if I look at the next requirement, it says the parties agree that the commission should allow only the absolute minimum amount of dollars necessary to keep the nuclear option available. Do you see that?
Yes, that's correct.
Okay, did you do that?
Yes, so after this order, we significantly reduced spending to just those activities that were necessary to receive the license and be in a position to deploy the plant by the 2021 to 2023 timeframe in the order.
And when it comes to the actual pre-approval for expenditures that was included in this order, did the company stay within the pre-approval amounts for the timeframes listed?
Yes, as we ramped down spending, recognizing that we were no longer doing things like ordering long lead equipment and doing detailed design engineering, that we spent significantly less dollars, and we came in during the time period in the settlement well below the amounts stated in the settlement.
And understanding there may be some differences in terms of whether or not a return should be earned on the unamortized balance in this case. Has any witness in this case presented evidence to suggest that the company's activities in pursuing the COL for the Lee Nuclear Project were imprudent?
No.
Thank you, Mr. Fallon. Chairman, I have no further questions.
Thank you. Any recross?
Chairman, I have no recross, but I think I would at this time like to ask the Commission, in light of Council's questions and mine, to take judicial notice of orders number 2008-417 and 2011-454 and any required filings submitted by the company pursuant to those orders.
We will take judicial notice.
Thank you,
sir.
Elliott, for doing that. Thank you.
Commissioner.
One follow-up question, Mr. Fallon. Since you own the property and since you're on the river and have already constructed a dam, I'm just curious if you looked into the possibility of retrofitting the site for a hydroelectric facility. Is that a possibility?
I don't believe that's a possibility. I don't think the flows in that part, and it's just downstream of 99 Island, so I don't think that's a real possibility.
Thank you.
Commissioner Belzer, you had a question.
No, I was just going to, with regard to those requests for judicial notice, are you asking that those quarterly reports also be included in that, Mr. Elliott?
Yes, ma'am.
Okay. Could I ask that y'all get together and submit a packet of the materials that that y'all are asking judicial notice? Because I don't feel like going back and diving through the DMS for that.
Well, I think
I'll let counsel talk first, but if I can interject, I think based upon the cross that's been heard by the commission today, the primary things that would need to be judicially noticed are just the two orders, which would be the 2008 order and the 2011 order.
Well, but
that makes it easier for the commission to...
Any required filings submitted?
Well, in particular...
Well, I believe counsel asked for that, and at a time before... Commissioner, you recognize the difficulty that might create. I would suggest that based upon the cross, it would be logical to just include the two orders which we both used in cross-examination rather than the broader docket.
Well, let me in particular ask the Commission to take judicial notice of the filing April 1, 2012 through June 30.
Man, your microphone's not working. I can't hear you in the back anyway.
Let's let me amend my request to seek judicial notice of simply the quarterly filing that I cross-examined at least one or both these witnesses from, Duke Energy Carolina's report of Lee Nuclear Station activities and expenditures pursuant to the settlement agreement in the second order, April 1, 2012 through June 30, 2012.
I guess my concern, Commissioner Belser, is that, or Mr. Chairman in the commission, is that we're taking judicial notice of an order. That's one thing. We're now entering exhibits from the docket. That's something different. If Mr. Elliott had marked that and wanted to include it as exhibit, that's something we could deal with, and I could make an objection if I wanted to at the point in time it was moved. But to just take judicial notice of an individual report, to me, is different than when we're talking about just orders. The orders of the commission speak for themselves in our orders. This one. But he didn't mark it. If he wants to mark it, he mark it. Mr. Chairman, if it makes it easier and Mr. Elliott just wants to mark it, we won't object to it if it's marked.
Okay. Because I'm agreeing with him on what he was talking about. I don't think we need to get into the additional things, but we can mark it.
And admit it as a hearing exhibit? That's certainly.
Okay.
Objection to that.
We'll do that, and without objection.
Mr. Chairman, for clarification, what number is that? Thank you.
19. Okay. Is there anything else?
May I provide a copy in the morning, or at least provide a copy now and get a copy back in the morning? No, I tell you what, I'll give you this one, and I'll make the whole copy back.
That would be a very good plan. Yes, sir. Microphone.
My client would have probably fired me. Mr. Fowler and Mr. Diaz, we'd like to ask that they be released.
Absolutely. We thank you, gentlemen, for your testimony, and you are excused.
Thank you very much.
Thank you.
Okay. All right. We'll start with your next witnesses at 10 o'clock tomorrow morning. We are adjourned.